Welcome to CityWorks, a production of the City University New York School of Labor and Urban Studies and CUNY TV. I'm Laura Flanders. Each month, CityWorks explores the lives of working people on the job, at home, and in our communities to explore ways to better advance an agenda of social and economic equality. Today, we have two outstanding guests in the realm of work and the laws that protect workers. Irene Tung is Senior Researcher and Policy Analyst at the National Employment Law Project, or NELP. Founded in 1969, NELP stands out for its exceptional leadership in the protection of working people. Dr. Tung's recent efforts include research and advocacy in support of campaigns for just cause legislation in New York City and Illinois. She's also reviewed Amazon's disciplinary and surveillance policies, and she sought to hold that company accountable for high rates of injury among its warehouse workers. Most recently, Dr. Tung and NELP have tackled the large number of jobless workers excluded from unemployment benefits. We also welcome Ellen Dichner to today's program. Ms. Dichner is one of the nation's leading experts on employment law. She practiced labor and employment law for more than 25 years, and during President Obama's administration, she served as Chief Counsel to the Chairman of the National Labor Relations Board. Ms. Dichner's legal expertise extends to union organizing campaigns, collective bargaining negotiations, arbitrations, and litigation in federal and state courts. Today, she is Distinguished Lecturer in Labor Studies right here at the CUNY School of Labor and Urban Studies. Welcome to you both. So let's just jump right in. It might be a surprise to a lot of our viewers to know that you can actually be fired at will in this country for no particular reason, with no opportunity to fight for yourself or to improve or correct your behavior. That's mostly true, but not quite entirely true. Can you lay out the picture and what is so distinctive about the situation that workers in the U.S. face in comparison to other countries?
Right. So Laura, as you mentioned, in the United States, you can be fired for really any reason under the sun. It could be because your boss doesn't like how you laugh or your taste in music, and they don't have to give you a reason or even warning or severance if they let you go. This is for most workers and most employers. There are a few exceptions. The law, there are laws against discriminatory firings or firings that are retaliatory for union organizing, for example. But given the fact that your boss can just say, well, I fired you for some other random reason. I didn't like your, jeans yesterday. It's very, very hard for any worker to prove that their firing was retaliatory or discriminatory.
And the burden's on them to do it.
Exactly.
So, Ellen, there are people that will say, but aren't there laws against this? Aren't there?
Of course, there are laws. There are various statutes that protect workers who are retaliated against for asserting their rights under the statutes, discrimination law, wage and hour laws, and importantly, the National Labor Relations Act, which protects workers who are disciplined, demoted, fired for exercising their rights to not only seek to unionize their facilities, but also where workers join together to improve their working conditions. So workers who walked off the job during COVID, who were not involved in a union campaign, those workers are protected under the National Labor Relations Act. And what's unique about the National Labor Relations Act is the agency, the NLRB, that enforces that law. They will investigate charges, and if they find merit, they will assign a lawyer to prosecute the employer who has violated the workers' rights. The big challenge, I think, for the agency today, a couple. One, financing. The NLRB did not get a raise to its funding since 2014. Very recently, they did get some additional funding, but they are so underfunded, so understaffed. And at the same time, there's been an increase, substantial increase in the filing of union petitions and unfair labor practices. One of the other big challenges that the NLRB and the General Counsel of the NLRB faces is that the law has developed largely through the courts to limit the rights of workers. And so there are issues around mandatory meetings that workers are required to attend by their employers, where they are forced to hear anti-union messages. And sometimes this is just repeated day after day after day. So there are definitely significant limitations in the law. The remedies are weak. And as your listeners probably know, there is the PRO Act that has passed the House, but not the Senate, that would amend the National Labor Relations Act to make it more responsive to workers and more consistent with its original goals.
How did it get to be so underfunded?
Politics, politics. The agency is not favored by Republicans, and they have, refrained from funding it at a level where it could function. I mean, when the president passes wage increases, for example, to federal employees, that comes out of that budget that did not get increased since 2014 until a very modest increase recently.
All right, so if those are some of the challenges at the federal level, at the local level there have been some changes, at least some initiatives that people could get excited about. What's happening right here in New York with respect to this just cause legislation, and what is it exactly?
So New York City adopted a just cause protection law for fast food workers a few years ago. It was fought for and won by fast food workers. In fact, there was just a case a few weeks ago in which a Starbucks worker, Austin Locke, who was one of the main organizers at his Starbucks location and had been fired, he was able to get his job back as a result of this fast food just cause law in New York City. And then now we are looking to expand that law for all workers universally in New York City. There is a bill called the Secure Jobs Act that was introduced in December that would require employers, most employers in New York City, to provide fair warning, a process, and a good reason before firing an employee, and to prove that, to have the burden be on that employer to show that that firing had cause.
That seems pretty exciting. Are you excited?
We're very excited. We're very excited. Yeah, it's we have a lot of momentum, and we're optimistic that. And
New York's not the only place.
No, so there's also a bill in Illinois, and there's been tremendous interest around the country. This is one of the laws that can actually be passed by cities and by states. It's not preempted, federally, and so there's a lot of opportunity there, and we're excited for the possibilities.
Now, I've seen this discussion often framed within the context of kind of racial and gender discrimination. Can you talk about that, the ways in which severance isn't as kind of neutral as it looks?
Absolutely. So severance is something that we're including in these bills, and it's very, very important because so many workers are devastated when they lose their jobs. And this, the data shows that Black and Latinx workers have longer spells of unemployment, when they lose their jobs. And severance can make a huge difference, and it's not that expensive, really, for employers. And the other thing is that undocumented workers, if they lose their jobs, it would be very hard for them to be reinstated under a just cause law. But they would be entitled to severance because it would be similar to back pay when they are, when they experience wage theft and there's a violation of minimum wage laws. Undocumented workers are able to seek remedies for that back pay, so it would be the same for severance.
Is there a national initiative that mimics what's happening locally or statewide? We
are, in fact, speaking with many organizations around the country and working towards a national effort and to draft some national legislation on this. And I think the goal really is a cultural change here in the United States, right? To really recognize that the way that we understand work in this country is problematic. We should not be forced to prioritize work over our families, prioritize work over our health. I think that's at its heart what this movement is about. So, I think it's long overdue here in this country.
All right, well, we're going to take a quick break, and when we come back, continue this conversation. There are some sort of pitfalls in this trajectory towards just cause legislation, and there's yet more context that would be helpful to unpack. We'll be right back. You're watching CityWorks.
The CUNY School of Labor and Urban Studies is the 25th and newest school under the CUNY umbrella. Dedicated to public service and social justice, the CUNY School of Labor and Urban Studies offers undergraduate and graduate degrees in the areas of labor studies and urban studies, and certificate programs in labor relations, public administration and public policy, healthcare policy and administration, and community leadership. We pride ourselves on being an institution that brings together activists and academics. Find out more at slu.cuny.edu.
Welcome back. We're talking with Irene Tung and Ellen Dichner here on CityWorks. Coming back to Just Cause for a second, Irene, it seems to me so important what you said earlier about the need for a culture change. The Americans have become so maybe familiar or just accustomed to the conditions in which we work, that the idea that we are an outlier nation, I think, is still news to many people. Do you work internationally? Is there any sense of kind of international support that you might be able to bring to this shift from at-will to just cause firing?
Well, most people internationally are shocked to find out that the U.S. is still living like this. And a lot of immigrants here in the U.S. are also shocked, that back in my home country, this is not how it was. Yes, I think that, there is sort of international judgment on the U.S. For this situation. And, go ahead.
I saw that electronic tracking was included inside the legislation. Why, and what are we talking about there?
We found that with the growth of these new forms of electronic surveillance, for example, where the employer tracks if you're moving your mouse enough, or if you turn your face away from the screen, or at Amazon, we've just seen they're counting every second that workers are not packing their boxes. If they, take a drink of water or go to the bathroom, then they're docked, punished. And so this is made possible by these new technologies, which employers can use these to just track every little infraction and make that a punishable or a fireable offense. And that would just undermine any just cause protections that we're able to establish here. So for that reason, we've included some provisions on electronic monitoring, specifically in the use of discipline and termination, to restrict its use in discipline and termination.
Is this something that's coming up under the NLRA? I don't see.
Yes.
Did they anticipate tracking back in 1935?
No. No. Under the National Labor Relations Act, it's unlawful for an employer to engage in surveillance of employee union activity. And so with the technologies that we have today, the ability to surveil employees has really increased.
So for people that are watching out there, maybe they're in a union, maybe they're not, talk about let me ask you what provisions, how can they avail themselves of this situation, of the movement around at will in New York, of the existence of a NLRB that is perhaps under new leadership? How does it help the average Joe working here in New York, or Jane?
Workers don't know their rights. Many workers have no idea that the National Labor Relations Act exists, and certainly they probably have very little idea that the just cause provisions and the other protections that have been won exist. So it's, the culture in this country, the media in this country does not inform workers of their rights. Workers are an insignificant population as far as the media is concerned. I mean, we look at the press, it's all about money, it's all about corporations, it's all about things that impact workers. But there's very little information about the protections that workers have and workers need and why they need that. And in a day when we are living with the greatest disparity of wealth, one would think an incumbent on the media, at least, to inform people of these important rights that they actually do have.
And as you said, you don't have to be in a union to avail yourself of those rights.
That's absolutely right.
Irene, anything you'd add?
So just cause protections are widely and broadly popular across the political spectrum. Democrats, Republicans, 70% or more support for these kinds of laws. So I think that there's a huge opportunity for a movement here that really brings people together around this issue that affects so many people, and to really go after that culture change that we were talking about. And I think, when you think back to the Fight for 15, back 10 years ago, it seemed like such a pie-in-the-sky demand when they made it. And it was the fast food workers here in New York City that made that demand. And it is the fast food workers here in New York City, again, who have catalyzed this movement for just cause protections. And it may seem like an uphill battle right now, but I think we can draw inspiration from the Fight for 15 and start building this movement.
$15 an hour. Why do you think fast food workers have been such leaders in this?
I mean, I think that they are really at, I think they see the sort of corporate power in its rawest form. They are in these jobs where these companies are making billions of dollars off of their backs. The work is hard, and also these are oftentimes majority Black and brown workers who see how racism and workplace injustice, sort of go hand in hand. And so I think, their leadership in these movements has just been invaluable. And I think, there's just a huge opportunity to bring people together here.
Ellen, I so appreciate you mentioning the media, because I feel as if we do get sporadic coverage, a victory here or an organizing effort there, and then we kind of lose the thread. And that reminds me of what you said about the delay that is a consequence of the underfunding of the NLRB. Who does that delay serve when it takes so long to go from an organizing campaign, perhaps, to getting an election, to getting a union recognized, to getting a contract, as you mentioned?
Serves the employers. We have seen an upsurge in union organizing and activity in the last several years. It's been greater than in my lifetime as a labor lawyer, and it's widespread. Workers understand in a real way the contradictions of our system. And so, when the law delays any kind of remedy, it is very frustrating to workers.
How can people get involved in the struggle for just cause, Irene?
Well, they can certainly contact us at the National Employment Law Project, and we'll get them plugged in.
And anything they can do to help the good folks at the board?
I would say keep organizing, keep making their lives difficult, keep organizing, keep bringing the charges, keep asserting your rights.
All right. Thank you so much, Irene Tung and Ellen Dichner, for speaking with me today. Not so long ago, the CUNY School of Labor and Urban Studies hosted a conference titled How Workers Win. We're pleased to share some highlights.
An integrated strategy to address white supremacy and patriarchy is not just a moral stance, but it is also a power stance. In 2021, Amazon workers in Bessemer, Alabama, mostly Black, called for help in their bid to form a union with RWDSU, as we heard on the panel earlier. Many workers shared how radicalized they were after the murder of George Floyd in Minnesota by former police officers. After having participated in the 2020 summer uprisings for racial justice, it gave them the courage to speak out about their own conditions during the COVID-19 pandemic. And as we heard, their union election is still too close to call. During that same week, as we all know very well, the Amazon Labor Union was also able to win their union. And that was also because people were radicalized by racial injustice after Chris Smalls and others were arrested and fired in the early days of the pandemic for demanding better COVID protections. You contrast these victories with the setbacks experienced by two unions in 2017 after attempting to win union elections without centering race. Both the UAW's attempts to organize workers at the predominantly black Nissan facility in Canton, Mississippi, and the machinists' union's attempt to organize workers at Boeing's Charleston, South Carolina facility did little to emphasize how both companies recognized their unions when workers formed in other locations that were not majority black, focusing instead on traditional issues of wages and corporate greed. And in both cases, we lost, and it wasn't close. Workers active in today's struggle are winning because they center race and gender, and the experiences of exploitation they've experienced because of it. That is why workers are activated and why we're making progress.
We want to be a part of the answer. We obviously cannot be the whole answer, but our belief is that to build a multiracial movement of workers in the South, especially the Deep South, especially the Black Belt South, the Black-led multiracial workers movement, can really fundamentally change this whole country. I think there's a misconception about Southern workers oftentimes that Southern workers are more anti-union than workers across the rest of the country, and I actually think that is not true at all in my experience. I think Southern workers are ready for the union, want to form unions, want to build power, actually have led the most powerful worker movement in this country, radical Reconstruction, and are waiting for organization and are ready to build organization, and that's what we believe and that's what we've seen. All right, so how do we organize? There's a tradition of popular education in the South, specifically in the workers' movement in the South, and we seize on that tradition and make it central to the work that we do. We define popular education as a participatory process using workers' own experiences to analyze the world and create strategies for change. So to this end, everything we do is popular education. Every organizing conversation, every social media post, follow us on TikTok, follow us on Instagram. We're constantly engaging in pedagogical processes to build the protagonism of Southern workers. We have education retreats. We really place a heavy focus on popular education. And the reason for that, I think, is because unions are central to the fight for democracy.
I think strikes, and look, let's be honest, they're really scary, right? And they're really scary to organize, and they're really scary when you're out on strike. My own experience when I was locked out at Yale University, I was personally threatened in an email by the dean of the graduate school and the faculty member I was teaching with that if I did not return to the classroom, because I was respecting the picket lines of Local 34 and 35 at the time, that I would be brought up in disciplinary charges by the university, right? And every worker who chooses to go on strike feels that moment in one way or another, whether it's from the boss, whether it's from their coworker, whether it's from their family members, right? Family members who are saying, what do you mean you're gonna walk out on strike? Like, I rely on you to bring home a paycheck every week so that we can pay for our kids to, live. So those moments of fear are tangible. And the boss uses those moments of fear. And the boss also uses those moments of fear to convince folks that striking won't work. And I think that's the second thing that makes striking hard. There is a culture that striking does not work. And look, we can say, does that historically go back to Patco and Reagan and blah, blah, blah? I don't know. But look, there is a culture that folks think striking doesn't work. And it's especially true in the industries that we represent and unite here in Local 26. Why? Because to be honest, when we walk out on strike in a hotel, it does not shut down. It is ingrained in at least our industry sometimes that, hey, you walk out, you're not, ending the means of production or whatever we're trying to do. That it's going to keep happening and they're going to wait you out. And that's another way in which I think fear makes striking really hard. And then the last thing I'd say is once you're out on strike, and we've had some long strikes in Local 26, keeping people out on strike, if victory isn't immediate, is very, very challenging. You have to support people who are on strike. I know a lot of times folks, the service model, and yeah, there's problems. But listen, folks need to get strike support. folks need to get money as strike support. They need to get food. They need to get help with talking to their lenders. All of this stuff, you need to build a significant infrastructure, especially if a lot of people on strike, to help them out. Because with folks in our industries who are living paycheck to paycheck, 1 week of striking, they're freaking out about how to make ends meet. And if the union is not there to support them, it will be seen as the union's failure. I was asked before to say a couple words about how does it impact an organization to go on strike? And to be honest, it's mixed. My experience is it's mixed, right? Even strikes you win, because it's such an intense conflict. We were on strike for 90-something days at this hotel in Boston. And we were on strike with 97% the whole time, and we won. We got a great agreement at the end of it, but it was so emotionally challenging for our committee and for the folks who were in there that they're still scarred from it to this day, 4 or 5 years later, right? I think they would all say they'd do it again because we won, but it really, really can be challenging in terms of carrying forward the organizing afterwards. But it can also have a really amazing effect to take groups of workers who I think didn't believe that they could do stuff, like our folks at Harvard, and see that they can do it, see that they can win, especially against these sort of global multi-billion-dollar corporations. So thanks.
Well, that's it for today's show. Thank you to our guests, Irene Tung from the National Employment Law Project and Ellen Dichner, former Chief Counsel at the NLRB. If you have questions or comments, write to us at cityworks@slu.cuny.edu. For CityWorks, I'm Laura Flanders. Thanks for watching.